Good day. Welcome back to my channel. This is now our third episode, and for today, we will be discussing the case of People versus Sullano. It's a 2018 case, and this is about the elements of Section 15 of Republic Act number 9165, which punishes use of dangerous drugs. So let us now study the facts. On October 16, 2012, Senior Superintendent Nerio T. Bermudo ordered 50 randomly selected police officers under Butuan City Police Office to undergo drug testing pursuant to Section 36 of RA number 9165. Among those who underwent testing was PO1 Johnny K. Sullano, the accused in this case, a police officer assigned at Butuan City Police Station 5. PO1 Sullano's urine sample was received and submitted, and according to the chemistry report of the PNP Regional Crime Laboratory, the test conducted on PO1 Sullano's urine specimen gave a positive result for the presence of methamphetamine. The confirmatory test on the same specimen yielded the same result, so positive. Given the result of the random drug test and confirmatory test, Officer Bermudo filed a complaint affidavit against respondent, Officer Sullano, for violation of Section 15, Article 2 of RA number 9165. Instead of submitting a counter-affidavit, Officer Sullano filed a manifestation wherein he claimed that, number one, he voluntarily submitted to the random drug test ordered by Officer Bermudo, that the urine sample he submitted gave a positive result to the presence of methamphetamine. 3. He did not use the dangerous drug but had no means to contest the test's veracity. And number 4, he entered into a rehabilitation program with the Cocoon Foundation for Substance Abuse. PO1 Sullano concluded by pleading for the dismissal of the complaint against him. Thereafter, the case was filed in court. So an information was filed before the Regional Trial Court charging PO1 Sullano with violation of Section 15 of RA number 9165. During arraignment, PO1 Sullano pleaded not guilty. Trial then ensued. After the prosecution rested its case, PO1 Sullano filed a demurrer to evidence. It's a motion to dismiss. The Regional Trial Court granted the demurrer to evidence and dismissed the case. CA affirmed the same, and thus the case was elevated to the court. The sole issue here is whether or not Section 15 of Article 2 of RA 9165 requires the apprehension or arrest of a person for the latter to be considered as violating said provision of law. Because here, take note, Officer Sullano was not apprehended or arrested. He was caught with the positive result by virtue of that mandatory drug test ordered by his superior. So the state's contention here, among others, is that Section 15, Article 2 of RA 9165 does not exclusively apply to circumstances where the accused was apprehended or arrested. According to the state, once the results of the mandatory drug test showed a positive result, the persons tested may be criminally prosecuted under Section 15. In the instant case, or in this case, since there was an order for PO1 Sullano to undergo mandatory drug testing, and the initial and confirmatory tests gave a positive result, he was properly charged with violation of Section 15 in relation to Section 36 of RA 9165. So those are the contentions by the state. So what was the reply or answer of PO1 Sullano? PO1 Sullano argued that a person may only be charged of violating Section 15, Article 2 of RA 9165 if he was apprehended or arrested and later found to be positive for use of any dangerous drugs. So let us study the provision. What does Section 15 of RA 9165 state? So Section 15, use of dangerous drugs, they stated a person apprehended or arrested who is found to be positive for use of any dangerous drug after a confirmatory test shall be punished or shall be imposed a penalty of a minimum of 6 months rehabilitation in a government center for the first offense subject to the provisions of Article 8 of this Act. So the underlined portion here states that a person apprehended or arrested. Thus, the state still contended that Section 15 should be read in conjunction with Section 36 of Article 3 of the same law, which mandates the random drug testing of certain employees and pertinently includes police officers like PO1 Sullano. But the Supreme Court said that this argument is actually untenable, urging the inclusion of Section 36 in accusing PO1 Sullano of the crime will deprive the latter of the opportunity to prepare his defense and violate his constitutional right to be informed of the nature and cause of the accusation against him. Because here in the information, such provision of Section 36 was not likewise alleged. And the court then continued. The Supreme Court found no difficulty in harmonizing Section 36 with a strict interpretation of Section 15. Section 36, the last paragraph, states that in addition to the above stated penalties in this section, those found to be positive for dangerous drugs use shall be subject to the provisions of Section 15 of this Act. Thus, according to the court, this may be construed to mean that rehabilitation for 6 months in a government center, as stated in Section 15, may be imposed on those found positive of use of dangerous drugs through a random drug test. This reading of provisions would still pursue the intent of the law to encourage not the prosecution and incarceration of those using dangerous drugs, but their rehabilitation. The reading especially finds relevance in this case as respondent voluntarily submitted himself to rehabilitation. And the court added that the state's arguments that we have mentioned a while ago should all be rejected. According to the court, the state wishes to expand the coverage of Section 15 to cover those under Section 36 and beyond what is specifically limited by the wording of the statute under Section 15, even when the information only alleges a violation of Section 15. Because of the strict construction of penal laws, again, the court said this is not possible. The Supreme Court even cited the case of De La Cruz versus People as to the court's interpretation therein of the coverage of the phrase a person arrested or apprehended or arrested. So in De La Cruz, the court held a person apprehended or arrested cannot literally mean any person apprehended or arrested for any crime. The phrase must be read in context and understood in consonance with RA 9165. Section 15 comprehends a persons arrested or apprehended for unlawful acts listed under Article 2 of the law. So that's the limitation that the court reiterated in this case as previously held in the case of De La Cruz. So the court again explained the meaning, the coverage of the phrase a person apprehended or arrested. So again, not for any crime. It must be persons arrested or apprehended for unlawful acts under Article 2 of RA 9165. So the Supreme Court in this case affirmed the decisions of the Regional Trial Court and Court of Appeals dismissing the case against PO1 Sullano. So that's the case. I hope you learned something. The accused here was acquitted in view of the failure of the prosecution to prove that element of the offense of Section 15, RA 9165. Thank you for listening.